Hello, everyone. We are live. If you can hear me, then please let me know in the chat, and we'll get started in a few minutes with the substantive questions. I've got some that people have already written in, but we'll wait for everyone to join us. Mario, you hear me? Okay, great. How you doing, Mario? Do you have a question for me? All right. Well, while we're waiting for everyone to join us, I'm going to tell a story about a case that came out. The case is called YCC, so York Condominium Corporation 419 and Black. So this is a decision that was just released, and it relates to COVID-19 in condominium corporations. So the condominium corporation brought an emergency injunction to stop a renovation that was going on in a condominium unit. The renovation, I think, was actually at the painting stage. So not like, destroying walls or anything like that. And the condominium corporation had a concern that it was not safe for social distancing reasons to have contractors coming and going into the unit. So they went to court, and the first thing that happened was that the court agreed to hear the application on an urgent basis. So that was really interesting because courts are closed right now except for urgent matters. And the court held as a first threshold that that the issue of a renovation in a condominium unit was sufficiently important and urgent that the court would hear the matter. So right away, that was an interesting first step. The next thing that happened was the unit owner asked for an adjournment because she had not had time to hire a lawyer to respond to the condominium corporation going to court. And the parties came to an agreement that the renovations would stop and that the case would then be adjourned. But in the interim, that there would be no contractors, and in fact, she agreed to no visitors in the unit, although that doesn't appear to be what the condo was initially asking for. And so this case, I think, stands for the proposition that a condominium corporation can, in these limit things like Ensuite renovations and real estate showings and all kinds of things that would be otherwise legal or permitted if you had a single detached home, but when you live in a multiple dwelling residential building like a condominium building, the considerations are different and you can have more strict rules. So I think that was a really interesting case, YCC 419 in Black, and maybe after the stream we'll put a link to it in the video description. So just early case, and something that we can all see is consistent with the advice that we've been giving to condominium corporations for the last 4 weeks. So let's get to some of the questions. Joe wants to know about leaning or deferrals of condo fees at this time. Thanks, Joe. So that's a really good question. We're getting it a lot. We're still in the early stages because most people would only be affected now for their April monthly maintenance fees. And so you wouldn't have to lien necessarily just because someone missed 1 month's common expenses. So we would suggest, if the condominium corporation can, and we think it should, that you wouldn't lien right away for 1 month's missed fees. you would at least wait until you got to June before you would lien for a missed April common expense. And we don't recommend that you would defer payment of common expenses. And there's a good reason why. So we get asked about whether condos should reduce their fees, do a new budget, or tell people not to pay. And the problem with that is it's indiscriminate in terms of people's ability to pay. So some people have the ability to pay their maintenance fees without any financial hardship, and others do not. And if you reduce the fees for everyone, then you are not taking into account someone's ability to pay. And then so you take away your buffer, basically. So if the condominium corporation has an ability to tolerate a certain amount of non-payment, and they use that all up by reducing everyone's maintenance fees or deferring everyone's maintenance fees, then when someone comes along who really can't pay even the deferred or reduced amount, the condominium corporation has no wiggle room to enter into some kind of compromise. So we don't recommend that. And we would suggest, as a general rule, that you try to give people the time to make up the payments. Hopefully by June, people can make up their missed April payment. If they're out of work, they might have received their government emergency response benefit. And so giving people some time, as long as you're within the lien period, I think is just fine. But you got to put your liens on, because otherwise, as a condominium corporation, you're losing your security and you're getting prejudiced, and you're no longer having priority over things like the first mortgage. So it's really important that you get your liens on in time, but not until it's actually necessary to put them on. Try to work with people. Okay, next question. Miriam, how should we handle request from homeowners to suspend their maintenance fees until further notice? I just answered this question. So same question. You should try to encourage people to pay their maintenance fees, and you should only lien as necessary. So if someone missed their April payment, you don't have to lien until June, and perhaps by then they can make it up if they've received some sort of assistance in the interim. While I have a second here, I'll just reintroduce myself. My name is Bradley Chaplick. I'm a condominium lawyer. I work for the law firm of Horlick, Levitt, Lella, of course, and I've been doing this for more than 10 years. I want to remind everyone, if you haven't already, to please subscribe to the channel and hit the notification button. And when you do that, you can get notified when we do these live streams. We plan to do them weekly for as long as we're all, working from home and doing that stuff. And if people want us to keep doing it after that, we might keep doing it after that. Who knows? So yes, please subscribe, and we really appreciate it. And thanks everyone for being here. We've got looks like about 60 viewers. Maybe we'll get a few more as the minutes tick on. And let's take some more questions. Does a board have the right to restrict visitors to 1 or 2 per unit, and can you limit it to essential purposes? Ooh, big question. Okay, restricting visitors. So different condominium corporations are going to be in different circumstances, and for most condominium corporations, we do not think it's necessary to prohibit people from having visitors. It requires the condominium staff and the security, if you've got security, to make very difficult decisions about who is essential and who is allowed. It puts you in a position of potential conflict with a lot of people. So first, we'll distinguish between visitors and deliveries. We really are quite strong in our view that you should allow deliveries. So treat that differently than you would treat visitors. And then in terms of social visitors, I think the best approach is to sort of strongly discourage it if you can, without taking a position that it's formally prohibited. To me, that seems to strike the right balance. Just to say this is strongly discouraged. We really don't want you to have social visitors. The law prohibits social gatherings of more than 5 people. So you could certainly remind people of that they're not allowed to have social gatherings in their units that would result in more than 5 people who are not of the same household being in the unit together. So if that's what you're going for, Mike, in terms of restricting visitors to 1 or 2 per unit, so that you're keeping under that limit of 5 per unit, then I think you're on the right track. I prefer that it sort of be phrased as a strong suggestion rather than a formal enforced policy, because if you have it as a formal policy, you can get into conflict and you can get into difficult situations. I see you're talking about essential purposes. I think you mean by that accommodating people with disability-related needs, people who receive care. Of course, those types of visitors would be allowed. So, tough question. Are many buildings, this is from John, giving hazard pay increases to their frontline staff, security, cleaners, superintendents, similar to grocery stores that have been giving employees an extra $2 an hour? I don't know. I don't know if people are doing that, John. No one's told me about it. If they have, although I think it would certainly be appropriate. Yeah, if you've got a superintendent who's working and you think that the work is potentially hazardous and you want to provide like a danger pay bonus, I think that's appropriate. So go for it. But I don't know what other condos are doing. And then the question, is that solely paid by the condo corp, or is it shared between the condo corp and the service provider? So, okay, if you've got an employee and you're paying it, and if you've got like something like a security guard who's employed by a security company, you could contact the employer and offer to surplus or supplement their compensation somehow, in where you would contribute some of the money and the employer could contribute some of the money, and I think that's fine. My understanding is that the margins, the profit margins on security guard contracts are very, very thin, and there's not a lot of profit there. It's very price competitive, so the employers don't have a lot of room. They would have to charge you more if they were going to do that. One of our streetlights recently died on the corporation private road. Is this considered part of an essential service, and do we have to fix it? You should fix your streetlights. Providing outdoor illumination is a safety matter, and I think that would definitely be considered part of the essential maintenance for the safe operation of the property. There we go. Yeah, fix your streetlight. Try to do that as soon as practicable. Some contractors are confirming that they are not able to come during COVID-19 temporary business restriction unless it is an emergency. Yeah, so there are certain types of things where it's the actual wording is not emergency. Let me see if I can pull it up here and get the wording. The wording is maintenance services strictly necessary to maintain the safety, security, sanitation, and essential operation. So that's the wording. It's not emergency. It's a little bit of a lower standard than that. So I would say that the contractors are being a little bit conservative if they're telling you it has to be an emergency. It has to be necessary, but not an emergency. Street lighting would definitely be something that's necessary. Catherine, you might want to post notices available from the City of Toronto website, accepting those who may be assisting folks to effectively self-isolate. Oh, I guess that's answering someone else's question. Thank you, Catherine. Please speak about unit owners not allowing entry into their unit, i.e. backed up waste stack, which if left could cause damage to their unit and others. Okay, well, I guess that, so Barbara here, your facts are going to depend, right, on what you can and can't do. It is, obviously people are going to be very sensitive to allowing contractors into their units right now. I would say that it's going to depend on your circumstances, and you would have to be reasonably certain that, one, if you don't do the work right now, like it cannot be postponed, it's going to cause imminent damage to the building or property damage to like people's stuff if there's like a water backup or something like that. I think it would have to be more than this like hypothetical, it could cause damage. There has to be a reason to believe that it probably will cause damage, and so that it can't reasonably be postponed. And then if you're going in, depending on who the residents are, if they're vulnerable people, you might have to accommodate them in a number of ways to ensure that the work is done in a safe and sanitary manner, and that the residents are not exposed to any danger. So you would have to have special accommodations in place if you're going into someone's suite to clean out the stacks. Also, it would have to be clear that there's no other way to do it other than to go into the unit, that you couldn't access it from some other place, even if it's a little more difficult. So I think if you can meet those types of basic criteria, then you're allowed to go in. But if you don't, if the work can be postponed, it should be. And if there's alternatives, ways to sort of stretch the thing out so that you're more likely to last for a few extra months, then you should try to do that too. So avoid it if you can, and if you can't avoid it, then you have to go in. Can we cut the grass and do routine landscaping, or do we let the grass grow until this is all over? So this is similar to Mario's question about fixing the street light, except it's a different fact example, and you get a different answer. So you have to think about the standard that I just read out. I'll read it out again about what maintenance is permitted and what's prohibited. Some people were saying emergency. Cutting the grass is not an emergency, but the actual standard is, and I'll read it again. Maintenance that is strictly necessary to maintain safety, security, sanitation, and essential operation. So I don't think cutting the grass is any of those things. And I would say that you do not have to cut the grass. Can you, if you really want to? I mean, I suppose you could, but I don't think you have to. And if you can avoid it, I don't think you should. I think that's part of how we, set an example, and we don't ask residents to endure something that we ourselves are not prepared to endure. So you wouldn't cut the grass if you can avoid it. How about the deadline for sending documents like the PIC, especially in condos where owners do not provide email addresses? In this case, would the corporation be liable for delays in mailing? Yeah, so let's talk about what a PIC is, first of all. Many of us will know, but not necessarily everybody. Periodic information certificate has to be sent twice a year. It can be sent electronically to those owners who have provided their email address and agreed to receive it electronically. And I think for those owners, they would expect to receive it. And for people who have not, provided their email address, if it is possible for you to send it via mail, if you have the ability to do so, then I think you should. But if you don't have the ability to do so because you've closed your office and your management is operating at a reduced service level, then I do not think you would be liable for missing the deadline for those people who receive the PIC via mail. I think you would quite rightly rely on the state of emergency, and you would refer to the restriction in management services to only that which is essential, absolutely or strictly necessary. And you would say it is not strictly necessary that we mail you a PIC at this precise moment. We can do it a little bit later, and no great harm will come to you. And so I don't think you would be liable for any damages if your PIC was delayed. Thanks for the question. It's a really good one. Let's just see where we are here. Andy, can we be fined if one of our contractors who is not an essential service insists on working? Their excuse is that they are a single person. They are our landscaper. Yes, you can be fined. Absolutely, there are fines for breaching these rules, and you as the property manager, I think, would be within the category of people who could be fined because you have care and control over the property. And the fact that your landscaper is a single person is totally irrelevant to the factors in that emergency order. And you should tell your landscaper if the work that the landscaper is performing is non-essential, that they are not permitted on the property. And that's that. I think your landscaper wants to work because your landscaper wants to get paid, not because of anything else. And it's your job as the manager to say who's coming on the property and who's not. Hi, Brad. We're noticing continuous in-suite renovations still happening in some of our condominiums. Are there any specific guidelines we should follow to handle these owner renovations? Viola. Yes. First of all, in-suite renovations are themselves not prohibited by emergency order. So if you look at the revised order, and I'm going to pull it up again so that I can read from it, it allows in section 30 residential renovations and construction work that was started before April 4th. So if a renovation was started before April 4th, it is legal under the essential businesses list, but just because something is legal on that list does not mean a condominium corporation must permit it. So a condominium corporation can be stricter than that list if you have reason to do so. And in a multiple dwelling building, you do have reason to do so. So you would have to pass a policy. You would have to notify all the owners of the new policy. And then you would have to make certain exceptions, I would think, for renovations that are essential or essential repairs to make the premises habitable. And we're only talking about in-progress renovations now. We're not talking about any new renovations. There's no approval of new renovations possible because of the emergency order. So we're only talking about ones that were already in progress as of last week. You're asking them to stop. They're saying they don't want to stop. So you pass a policy making it clear that this applies to everybody. And then if you were aware that someone was still continuing in contravention of that policy, you would write to them and you would inform them they have to stop work immediately. And if they refused, you would escalate that to legal counsel. And then if they did not respond to requests from legal counsel to stop work, then you have the case that I talked about right at the beginning, just before 12 o'clock, YCC 419 and Black, in which a condominium corporation got an emergency injunction forcing a resident to stop her Ensuite renovations. So you handle it the same way you would handle basically enforcing a rule, but you have to pass the policy first, let people know about it, then manager letter, if not immediate compliance, legal letter, if not immediate compliance, potentially going to court, emergency injunction. Only in the extreme case, last resort. In the case of fire or EMS response, do we have an obligation to let them know if any person is quarantined and how or can we enforce positive COVID cases? So there is an emergency order in place for police, fire, and paramedics that they are allowed to ask someone when providing emergency services, what is your COVID status? And the person has to answer. And the police, fire, and paramedics also have access to public health information about who has tested positive for COVID-19. That is a emergency order that was passed recently. And so they would already have that information in most of the cases. But if they didn't and you were aware of it, you could definitely tell them if you knew. Just trying to find where we are in the chat here. Is it appropriate to expect property managers to be on site during this time? Ours has decided to work from home. We recommend managers work from home. Thank you for your question, Julia. We recommend people work from home if they can. And the reason is because of the emergency order saying property management services are to be provided as strictly necessary. I'll read it again. So property management services strictly necessary to manage, maintain the safety, security, sanitation, and essential operation of the property. So if you can provide those essential services from home, then you should. And you would, in any event, even if you were at the management office, the office would be closed and it would not be open to unit owners coming in and communicating with the manager. So you, that's the answer. Is I think it's appropriate for managers to work from home and be available by phone and by email and by video conference. And if they were to be in the management office, the office would be closed. So there's very little difference. Ron, can we restrict deliveries to food and medication? Can a shared facility gatehouse refuse to accept deliveries to be kept at the gatehouse until the person can pick it up? Okay. So you've got a couple different things going on here, Ron. You can't do both. So you can't not allow the deliveries up to the unit and also not accept them on people's behalf. So you have to be able to, our preference is that you would allow the deliveries to the unit in all cases, because there are many reasons why people would not be able to leave their unit at all. They could be in quarantine, having returned from abroad. They could be COVID-19 positive. They could be awaiting a test result. They could have had close contact with someone. They could be not feeling well, or they might be physically disabled and not able to leave their unit, or they might be a vulnerable person who's not leaving their unit for any reason, who's relying on others to bring their groceries and these kinds of things up to their unit. So you should not stop deliveries coming into the building and right up to the door, and in my view. And then if you were to somehow stop deliveries, and let's say you have a gatehouse and the delivery is to the gatehouse, then becomes your responsibility to take it up to the unit, which is not a responsibility that most condominium corporations would want to have. So the best option when you look at everything all together is to allow the deliveries. Thanks. Hi, Brad. What would you advise with respect to construction projects at condos, balcony restoration that began last year, permits in place? So this is Inka's question. It's allowed, it's legal, right? The renovation work commenced prior to April 4th, and you have your permits and everything. So you are lawfully allowed to continue, and whether you do so will depend on whether you think it's safe. The fact that it's a balcony restoration, I mean, that cuts both ways. It's outdoors, which is good from the perspective of resident safety. Also, people might want their balcony work to be done so that they can use their balcony sooner. So there's a lot of reasons why you would do your balcony restoration project if you think you can safely do the work. If it would require contractors coming into units, or if they're being inside the building a lot, then that's a negative factor and a reason why you might want to pause the work. But I think it's lawful, and there are circumstances where projects like this can proceed if they're essential. Work's done exclusively from the exterior. So yeah, I think that's great. So if it's exclusively from the exterior and there's no risk to resident safety, it's lawful, then these are all factors as to why you would continue. Can we limit access by residents' personal cleaners like housekeepers? I think this is Andrew's question. This goes back to the visitor's question, which came up near the beginning of the chat. And my view is that you don't want to get into this kind of stuff unless you really have to. There should be a reason why you're limiting people's housekeepers. You also have to think about the fact that you would be making exceptions for anyone who is not able to do their own housework because of disability or injury. So to avoid getting into all of those personal factors and to get into people's private lives, our suggestion is that you sort of strongly discourage it and that you don't prohibit it entirely, because then you have to get into this fact-specific inquiry to, like, okay, you have a housekeeper. Is it because you are, hurt your back and you can't do your own housekeeping? And if so, then we have to accommodate you. And if not, then it's not really what you want to get into these days. So try not to do this. Try not to stop the housekeepers coming in if you don't have to stop it. Leave it in people's own discretion if they want to have their housekeeper come into their suite. Most people would tell their housekeepers to stay home. For those people who didn't, there's probably a reason why. So, residents refused anchor inspection to proceed, forcing us to skip window washing. Concurrently, we had a leak in a unit, but caulking contractor cannot use non-certified anchors. How to proceed? Geez, part of the problem here is I don't understand what the anchor inspection refers to, but as to, you know how that relates to, oh, the caulking contractor can't use them. Okay, now I get it. Okay. So I think it's appropriate to skip your window washing, first of all. That would be a non-essential in my view. And then you have a leak in a unit, but the caulking contractor cannot use non-certified anchors. I guess I'm having difficulty understanding why the anchors are on the roof. So why would you need access to the unit to do it? I guess it just has to do with the design of how the thing all fits together. But I would not proceed with non-urgent repairs. And if the caulking on the exterior is something that you want to be able to do. It's a tricky question. It's really going to depend on how the physical dimensions of this are going to work out. But I think you have the right to do the caulking work, the window washing, maybe not so much. And to really figure out how to proceed, it's going to be fact specific, and we're going to have to sort of dig down a little deeper than perhaps a live stream would allow us. But tricky question, but some of the stuff looks good and some of it, the owners are right. Andy, further to my question regarding the landscaper, they are on a contract starting April 1. Are we obligated to pay them if they are not allowed on the property due to ramifications of COVID-19? Andy, this is an excellent question. This gets into something I wanted to talk about anyways, which is the law of force majeure and frustration of contract. So you have a contract requiring a landscaper to come and do grass cutting and spring cleanup and all these things starting April 1st, and you decide that they can't do the work right away. Do you have to pay them? It depends what your contract says. You have to look at the specific wording, and you might have a clause in there saying that someone is not liable for a delay if the delay is caused by a circumstance outside of their control. That's called a force majeure clause. Sometimes it's also called act of God, although that term has fallen out of favor. And the answer is that it is a defense for the contractor. So it would entitle the contractor to be paid even if the work is delayed. And so what you would say to your contractor is, the work that you were supposed to do in April is postponed, but you still have to do it just later in the year, right? So instead of coming once a week in April, you're going to do your big spring cleanup in June, and you're going to have to make up the time somehow. And then in that way, you pay them throughout the whole term of the contract, and they sort of make up the work. And maybe it's not exactly what you thought you were going to get, but you try and make it something close. And you do that by negotiation with your landscaper. So you would try to pay them and get your money's worth if you can. And if that's not possible, maybe you can try to negotiate some kind of price reduction for the month of April. So that's force majeure. And frustration of contract, which is something that doesn't work for the landscaper because the work can be done later. But take the example of the window washer. So you entered into a contract with a window washer that they're going to come in and do your spring window washing, and it can't happen because of COVID and the prohibition on non-essential maintenance and cleaning. And so that contract is frustrated, and that terminates the contract. It's not postponed to a later date. It's not going to happen. And then you don't have to pay. It's like the contract never happened. So those are the two concepts there. Robert, what about new balcony project that will start now and be completed only from the exterior building, no interior access? I think you're going to have a problem, Robert, because I think the emergency order is going to nip you because you didn't start before April 4th. So residential construction project involves renovation to residential property, and construction work was started before April 4. If you did not start before April 4, I think you might not be able to start. So even though you would want it to proceed, you might not be able to. We'll have to take a look at the permits and the dates and everything. So you might not be able to do it, Rob, for your balcony project. How about instances where the board is insisting that common area violations would need to be addressed by owners in the next few months. From Dreadbane. What do you mean? What do you mean? What do you mean common area violations? Like stuff on the balcony? Let's assume that that's what you mean. So we're going to assume that you're talking about owners who have installed things on the common elements that they're not allowed to install, and the board is asking that it be removed immediately, and the owners are saying that they can't do it right now because they can't get contractors in and it's not an emergency. I would agree with the owners, and you would postpone this till later in the year and then deal with it then. And you would just write to them and say, we're not allowing this, we're not waiving our rights, we're going to require you to do this when this is all over. And that's the reasonable approach to take. Property, the question from before about the anchors, hang from the anchor to caulk the leak. Yes, thank you, I got that. But it's going to be, you're just talking about having to check the anchors, so you want to check the anchors if you can, and well, maybe you have to send me an email. I see here. The anchors are on the large balconies and you have to go through the unit to access it. Not all anchors are on the roof. There you go. Okay, so that's, learn something new every day. If the board changes the condo to a non-smoking condo, do owners and renters need to be grandfathered? Fabio, a non-COVID question. Amazing. Okay, question about smoking. Smoking in condos. The question is, if you pass a rule to make your property no smoking, do you have to grandfather existing smokers? There is a couple of cases on this issue. So I'll tell you about one of the cases, Zilberberg. And in the Zilberberg case, the condominium corporation allowed smoking in the units, but prohibited it on the balconies, and they did not grandfather smoking on the balconies. And so the unit owners kept smoking on their balcony, and the condo told them to stop. And the question was whether they had to be grandfathered to the right to smoke on their balcony, and the court said, no, you did not. And the court in that case also said that you did not have to grandfather in all cases. So my view is, if you're going to prohibit smoking in the units and prohibit it on the balconies, you would grandfather existing smokers to allow them to continue to smoke in their units. Excuse me. And you would make the grandfathering contingent on the fact that it cannot disturb neighboring residents. And so then what all you're really allowing is for people who have always smoked and it doesn't bother anyone to be able to continue smoking in a manner that doesn't bother anyone. And if you get complaints that the smoke is bothering someone, then the grandfathering is revoked and then they can't do it anymore. And so I think that's a really nice compromise where everyone's needs are met. So that's how you do it. And you should do this by rule. And your rule has to be preferably written by a condominium lawyer who knows what they're doing and can write the rule in such a way that the grandfathering is done appropriately, and that's something that we offer to our clients. Ron, City of Toronto has a hotline set up, dial 301. Do you know the number to the hotline to report people that are not practicing safe measures in Vaughan? I don't know, Ron. I don't know what the number is off the top of my head to report unsafe practices in Vaughan. I wish I did know. I'll look it up. Let me make a note. Unsafe practices. Vaughan. I'll try and send that to you, buddy. But I don't know off the top of my head. I guess the first thing I would do is I would go to the City of Vaughan municipal website and check. That's what I would do. What is the responsibility of reporting any known case of COVID-19 in a building? I know of a building with 2 confirmed cases, and the board and management are in denial and don't want this info. Interesting. Responsibility of reporting, like reporting to who? Like to the owners? So they don't want the info disclosed. I see. Okay. So we recommend that if the condominium corporation is aware of a confirmed case in the building, that that residents be notified of this fact, but not any personal information about the resident. The reason why we do this is not because it would really change how people live their daily lives, but rather to counteract sort of people being scared of each other, or rumors, or I heard that there was someone in the building, I heard there were 20. You know, if you just post the information, everyone has the same information. I think everyone can deal with that information, as opposed to a lack of information, and then the information gets out in other ways that are less helpful. So that's why we think you should post. And I think, you know, saying that it shouldn't be disclosed or is not the right approach. So if the board becomes aware of it and it's confirmed, then you can let people know, so that people are able to trust that they're getting reliable information from management and the board of directors, and they're not forced to seek their information from unreliable sources like Facebook groups and things like that. Danielle, it was proposed a table be set up in the lobby for donations, food, a free exchange drop-off between residents. Is there any liability issue the corporation needs to be aware of before allowing? I don't think that there's like a serious liability issue for having a donation box in the lobby. No. I don't think it's something that the board necessarily needs to become directly involved in, but if it's an initiative by a group of owners who want to do something nice and engage in charitable activities, I think that that's something that the board can allow without attracting undue liability, and I think that's fine. Question edited. How about in instances where the board is insisting that trees be planted by owners on their backyard? Insisting that trees planted by owners on their backyard need to be removed. Okay, so this is a question from before about common area breaches where an owner has planted a tree in a backyard and the board is saying, please remove your tree, because it was done not in accordance with Section 98 of the Condominium Act, in which you get board approval and you do a Section 98 agreement. I think the removal of the tree can wait. That's my answer. I don't think it's an emergency, and yeah. So the board should wait. The board should wait until life has returned to normal. But just, you know, write a letter now saying we want to deal with this in the future, but we're not gonna bug you about it and force you to hire a landscaper to go out and remove your tree right now. It's not reasonable. If you don't disclose a name of an infected person, that causes just as much gossip, rumors, and anxiety. So okay. This question came up earlier. Another person asked me from via email about whether the name of the person should be disclosed, and pointed me to PIPEDA, which is federal privacy legislation, saying that PIPEDA allows personal information to be disclosed in an emergency. Isn't this an emergency? Don't people need to know who it was? All these kinds of things. So here's my response to that, because I had some time to think about it. Compliance with PIPEDA, first of all, even if it's true that you could disclose the name and not breach privacy legislation, compliance with privacy legislation is like your legal minimum. So that doesn't, just because you've complied with PIPEDA, it doesn't mean you've met your obligations with respect to privacy. There's a tort called intrusion upon seclusion, which we commonly say breach of privacy, but breach of privacy encompasses all different kinds of things. Intrusion upon seclusion is one category of breach of privacy. And the test is whether it would be, quote, highly offensive to a reasonable person. And basically accessing someone's personal medical information comes up in hospitals a lot. So certain people are authorized to look at medical records, and sometimes people who are not authorized look up those records. And when that happens, there can be legal consequences for breach of the patient's privacy in terms of their medical information. So there's a lot of case law about medical privacy, and it is basically the classic example of something that should be kept private. So based on all of that law, and the fact that someone would consider it stigmatizing if they were outed against their will as being COVID positive, I think that you cannot disclose the name as a matter of privacy, and that you would leave it to public health to have close contacts be told that they should get tested or self-isolate or all these kinds of things. So it's not the role of the condominium corporation to try to figure out who had a close contact with this particular resident. That's the role of public health. We let public health do their job, and condominium management can, I think, justify to most people that we're not going to disclose the name. That's not our role, but public health is aware and they're doing their job, and so that's that. So we don't want to tell people's personal medical information against their will. Breach privacy. What about monthly contracting, i.e. pool services? We close the pool. Do we still have to pay them for no work? Do you still have to pay the pool person for no work? So I guess if you are, it seems to me you should be able to suspend that contract. Like you should be able to, but it depends on your contract. So we have to look at the contract and see how it's structured, and see if it can be suspended or put on hold. If the person's not coming to do the testing, then you would say, we want to put this contract on hold for 8 weeks or whatever, and then when the pool reopens, we'll resume the contract. And if they're not willing to do that, like I said, it's going to depend on the wording of your contract. But it may be that the wording allows them not to come and to still be paid, so you have to check. Very, very interesting question about the pool contract. Some thank yous. Oh, you're welcome, Mariel. Barbara, the board wants a notice posted recommending residents use masks and gloves in common areas. Is board of directors in a position to make health recommendations? So, okay. I don't have a problem with the board providing health recommendations that are from reliable sources. Barbara, I think that's sort of the crux of your question, right? Is that, you know, we're not in the business of providing medical care, and we don't want to give people wrong information. So I think the best thing to do in your question about not being concerned about giving people medical advice, which is sort of goes beyond the scope of expertise of a board of directors, is to get the information from reliable sources like the City of Toronto, Province of Ontario, federal government, and then take that information and post it. And if you do that, I think that will satisfy your concern. And it may be that you can find updated information, especially from the federal health ministry and public health department, saying that it's acceptable or even recommended to wear masks in public, because if everyone wears the masks, then we're not all breathing on each other. So I think that's what you would probably do. And that way you're not forced as the board or the manager to write these things on your own and risk sort of getting it a little bit off. Okay. Our director's liability insurer said they're not sure about protecting directors if they do not disclose the name, but we should follow the lawyer's advice. Oh my gosh. Okay, this is going back to the notifying owners about someone who has COVID in the building. I stand by my position that you should not be disclosing someone's name against their consent, and that if you did that, you could be civilly liable for breach of privacy. So if you need to get legal advice on that, you should get it in writing and not necessarily just rely on a live stream, but try and get a legal opinion on that if you're still very concerned about it. But I think it's not an issue. How about instances are several boards insisting on sending pre-notice at this moment? Should managers provide a meeting estimate? Okay, so this is about AGMs, condo meetings, and the preliminary notice of meeting, and what should you do because you've got your meeting deadline coming up. So let's take the case of a condo that would have like October 31st year end, and therefore your meeting deadline was like April 30th and there's no way you're having a condo meeting, should you even bother sending out a pre-notice? I would send out some kind of communication to owners. I don't know if you would necessarily have to do it in the form of a preliminary notice of meeting. Perhaps that's not the right document to use, but maybe just something like a letter and explaining that we're hoping to do our AGM in July, and you'll hear again from us closer to that date once we've picked a date. And I think that would be totally sufficient. And if it so happened that you had your audit done and you could make the audited financial statements available to owners just because you had them, then that would be great too. Similarly, if you have a report or any kind of annual update that you want to give owners, you can give them all that information, even if you're going to give it to them again in a few months when you do the AGM. And I think that answers your question. So doesn't necessarily need to be a preliminary notice of meeting, just some kind of communication letting the owners know that you've turned your mind to the AGM and this is what you're planning to do. I think that's the best way to do it. The second best thing to do would be to just send a preliminary notice of meeting, estimating a meeting date, but you might have to end up resending it if things get postponed or dates change and that kind of thing. So probably not worth your while to send a preliminary notice, just send a letter. Robert, is force majeure common law versus needing to be noted in a contract to apply it? Force majeure, okay, this is Robert. This is very, very touchy legal question from Robert. Thank you. Force majeure is not a common law doctrine. It does not apply unless it is specifically written in the contract. That is what you're asking. So you have to look for force majeure clauses in the contracts themselves. Otherwise, you're then relying on other common law concepts. So I hope that answers your question. Look at the contracts if you're not sure if you have to pay them or not, or what you can do. And sometimes these contracts, there's sort of more to it than what appears on its face, and you might need to get a lawyer to look at it. We'll take a couple more questions. We've been going strong here for close to 50 minutes. That's usually about how long these things last. I'm just going to check my notes very carefully and see if there's anything I forgot. We talked about who's entitled to COVID-19 status information. We talked about keeping names private. We talked about spring maintenance. Someone had asked me earlier about flowers and whether that was something that could be postponed. My answer is yes, it should be. The black case right at the very beginning. Frustration of contract, force majeure. Oh, here's a question that we didn't get to yet that came in via email. Commercial vehicles in visitor parking. Someone asked about that. They have people who live in the building and who have commercial vehicles that they would normally keep at their business. And now they wanted permission to put the commercial vehicles in visitor parking so that they could work from home, and whether the board should allow that. And it occurred to me that the board could allow that. And the analogy is that the City of Toronto has changed its street parking enforcement. So whereas normally you would have like an overnight parking permit if you park on the street, and then you can't park on the street during the day because you take your car to work, they've said, no, people are working from home. We will not ticket people with parking permits who are parked during the day for like more than 3 hours, because we're assuming those people are home and they're following social distancing guidelines, and we want to encourage that. And I think you could do a similar rationale for your visitor parking, especially if the number of visitors is reduced and the supply is there and you're not going to cause a shortage. So definitely something to consider. Let's see if we can do one or two more questions and then we'll wrap it up. Once again, on your way out, please do subscribe if you haven't yet. We really appreciate people subscribing and hitting notification, and then you are aware when we post videos, and it might not just be all live streams, we might post other stuff, other information, and trying to get people the information that you need to be able to do your jobs. So, Gary, our swimming pool needs to be drained and repainted. The people that test the pool water on a regular basis would be the ones to do the work. Can, oh, something's popped up here. Can this be considered an essential service? I guess I would need to know why. Why does your pool need to be drained and repainted at this precise moment? Like, is something going to happen to it if you postpone it till later? Probably not, right? Repainting the pool seems to me something that you could do at a later date. So does not seem to me that it's strictly necessary for safety. I think it's aesthetic, but I'm not like a pool expert. So let's assume that the work is aesthetic in nature and that you should do it later. So you would, I know it seems like a good idea to do it now because the pool is closed anyways, but that's not the right approach here. The right approach is that anything that can wait should wait. So that's the recommendation that I would give you, is to wait. All right, that runs through my list. That runs through your list, I think. Now seems like as good time of any to call it for today. Thank you, everyone. I really appreciate you taking the time to join me. This was a great live stream. I really like hearing your questions and getting a chance to talk to everyone. And again, thank you so much, and hope you're all staying home and staying safe. And we'll see you again next Wednesday, 12 noon. And keep an eye out for our FAQ, frequently asked questions. We keep them up to date. We're always updating it. And so we've got an April 8th version out there. And if you'd like to get your hands on it, it's got all the latest information and you don't have it yet, you can send me an email, bchaplick@HLD Lawyers, and I'll be happy to send it out to you. Thanks again. Bye, guys.